He was taken from us too soon, too early.
Troy was white. It may have been different.
Now, turns out he did not do any of those things.
5 people wrongfully sentenced to death. Number 5, George Stinney. The death penalty divides opinion across the United States, but one of the most insistent arguments is the fact that it's irreversible. One of the most clear and devastating examples of this is the case of George Stinney. Stinney was executed at the age of 14 years in 1944, but it took a full 60 years for him to be exonerated after death. The unacceptable nature of situations such as this have led to a public outcry on the use of the death penalty in general. In this specific case, Stinney was accused and convicted of the murder of 2 girls, Betty June Binnicker and Mary Emma Thames, aged 11 and 7. The arresting officer claimed that Stinney had made a confession and told him where to find a piece of iron likely to be the murder weapon. The trial handed out numerous unforgivable injustices to the defendant. The only written version of the so-called confession was by Deputy H.S. Newman, the very same arresting officer. To add to the torment, no Black Americans were allowed in the courtroom, only white. To add to the obvious prejudice issues and racist climate, Stinney was Black and the officers and prosecutors were all white. So you can understand why this would hold an immediate unfair racial bias in the case. His court-appointed attorney, Charles Plowden, at the time was campaigning for election to local office and clearly didn't want to rock the boat when the police officers were on the stand. He failed to offer any sort of real defense and lacked the ability to challenge even the most basic of weak evidence. When 2 different versions of the confession were presented in court, Plowden gave no real indication of how this could, at the very least, offer inconsistencies in the prosecution's case. George Stinney was wrongfully sentenced to death by execution by electrocution and was killed on June 16, 1944. His family were only allowed to visit him once between the time of his arrest and the day he was brutally executed. Theories of police corruption surround many cases, but the most frightening thing is how long after an incident happens, there can still be forces of darkness lurking around the corner. Years later, in 1995, Stinney's 7th grade teacher, W.L. Hamilton, was interviewed by a publication called The Sumter Item and had mentioned that George carried around a knife with him and had gotten into a fight that very day with a little girl and scratched her with the knife. Stinney's sister denied the allegations, and when she reached out to Hamilton to ask why he would make this up, his alleged response was, "Because they paid me." In 2004, a local historian decided to dig back into the case and eventually created enough of a stir that a team of South Carolina lawyers took notice. After nearly 10 years of solid work, the Civil Rights Restorative Justice Project and the Northeastern University School of Law jumped on board to help, and soon after, a motion was filed for a new trial in 2013. The new trial was to be opened based on new evidence that could potentially find George Stinney innocent. Instead of approving a new trial, the judge, Carmen Mullen, completely vacated Stinney's conviction. It was clear that not only had he not had a fair trial, but that the new witnesses and mountains of evidence pointed to the fact that his confession was coerced. Not long after, a new suspect was under scrutiny. George Burke Jr. had the spotlight thrust upon him when numerous whispers had steered the murder in the direction of him. Numerous witnesses spoke of Burke's lumber truck driving past the girls as they walked down the road and potentially picking them up. Deathbed confessions were never proven, but also spoke of when pointing the finger at a murderer from a wealthy white family at the time, something Burke Jr. most certainly was. It was important to note that the descendants and family of June and Mary Emma, the murder victims, claim although they didn't necessarily agree with the execution, they personally felt that George Stinney was still the guilty party. The horrific culture and history of that era is clearly shown when all they had was 3 white cops who said he did it, and no witnesses. The trial lasted shorter than a long movie, and without the defense lawyer even cross-examining the police, how can we not believe that there was bias involved? It makes a mockery of the entire justice system. A bill was introduced in South Carolina in 2022, and the George Stinney Fund was set up to offer payment of $10 million to the families of the wrongfully executed in the future. Number 4. Carlos de Luna.
Police find 21-year-old Carlos DeLuna a few blocks away, hiding underneath a truck. He's brought back to the scene of the crime where an eyewitness positively IDs him. Even though there are no fingerprints, no physical evidence linking him to the scene, he becomes the lone suspect. At trial, he testifies another man committed the crime, but Texas seeks the death penalty and gets it. DeLuna is executed in 1989.
Carlos DeLuna may have been a case of mistaken identity rather than corruption. However, there's still no acceptable explanation as to why this man was allegedly wrongfully executed. Carlos DeLuna was executed by way of lethal injection on December 7, 1989. He was charged with the murder of 24-year-old Wanda Lopez, a gas station attendant in Corpus Christi, Texas, on February 4, 1983. Lopez was stabbed to death in what appeared to be a robbery. Numerous eyewitness accounts varied in the report. Some saying they saw a man with a knife and dark pants and saying he sported a mustache. Others saying he was clean-shaven. Ultimately, a police pursuit ensued, and DeLuna was found without shoes or a shirt, hiding under a truck a few blocks from the scene of the crime. There was no blood found on Carlos DeLuna, which is something to bear in mind considering there was a lot of blood at the scene of the fatal stabbing. Upon DeLuna's arrest, two of the witnesses looked into the back seat and identified him as the killer. DeLuna was later also picked out of a lineup by eyewitnesses. However, the waters got murky when a shirt and shoes were found on a nearby property, most likely belonging to DeLuna, and after forensic experts examined them, no trace of blood was found on either. Enter Carlos Hernandez, the man DeLuna had said he personally witnessed attacking Lopez.
That other man is Carlos Hernandez, says Liebman, the man Carlos DeLuna identified as the killer and the man prosecutors never pursued, despite clues Liebman has now unearthed.
According to DeLuna, he had met with Hernandez earlier that day and went to the bar with him across the street from the gas station. He declared that Hernandez had gone to get something from the gas station and took so long to come back that DeLuna went looking for him and caught him in the act. He was concerned about his previous convictions, which is why he ran away. DeLuna, however, never identified the mugshot of Hernandez. DeLuna's testimony changed regularly, but another theory was that he and Hernandez had both tried to rob the gas station, and Hernandez ended up killing Lopez in the process. 4.5 hours was all the deliberation needed for the jury to convict DeLuna of capital murder. Whilst on death row, he claimed, "I was standing there when someone else did what they did, you know, but I don't want to name no names." Following up with, "Maybe one day the truth will come out." And indeed, it did. But too little too late, as it was a long 23 years after his execution that James Liebman and 12 students from Columbia Law School in New York extensively researched the case to find out what they thought to be the truth. The Columbia report had a number of leads suggesting that Carlos Hernandez had in fact committed the murder and even bragged about it to fellow cellmates while he was in prison. The matter won't change the impact it had on the death of Wanda Lopez, and it certainly won't change either Hernandez or DeLuna's life, as both are long since dead. The former, who died in prison in 1999 of a fibrosis that attacks the liver, causing disease.
Maybe one day the truth will come out.
Number 3. Troy Davis.
Whether Davis's case would have gotten a greater re-examination if he were white and not black. Before Davis died, he turned to the prison staff who were taking his life and told them, "May God have mercy on your souls."
Police murders are generally always high-profile cases that shed a light on the difficulty of their job and offer an insight into the tension between cops and civilians in certain parts of the United States. However, the conflation of events and high emotion of the crime should never leave the potential for a person to be falsely imprisoned and executed for such a crime. 7 prosecution witnesses claim they saw Troy Davis shoot and kill off-duty police officer Mark McPhail during a fight in a parking lot. No murder weapon was ever recovered. Davis was sentenced to death after a short deliberation in late August 1991. Subsequent appeals and habeas corpus proceedings unearthed new findings that would lead any normal human being to believe that this could have been a wrongly imprisoned man. During the federal appeals process, 7 of the 9 witnesses changed some of their testimony, and many of them alleged to have been pressured by authorities to give their original account of events. Human rights groups campaigned after his first execution date was set for 2007, and numerous celebrities spoke out to the fact that all the necessary evidence should be heard in order to save Davis's life, including Nobel Peace Prize winner Archbishop Desmond Tutu. On July 16, 2007, a 90-day stay of execution was allowed due to the large-scale public pressure and enormity of evidence suggesting that Davis was innocent. A second and then a third execution date was set, and both were delayed as by Supreme Court order, and a federal hearing was explored. After the hearing, two key pieces of information were introduced. Firstly, Benjamin Gordon testified that he was present on the night of the crime, and he saw his uncle, Sylvester Coles, was the man who shot Officer McPhail. Secondly, other prosecution witnesses who initially stated that Davis had confessed to them now testified that Davis had actually never done anything of the kind. Unfortunately, the renewed Supreme Court petition filed by Davis's legal team was rejected and subsequently resulted in a new execution date, a date that stayed despite the best efforts of the public. On September the 21st, 2011, Davis was executed by lethal injection. His final words rang through the corridors like a truth bomb. Well, first of all, I'd like to address the McPhail family. I'd like to let you all know, despite the situation, I know that all of you are still convinced that I'm the person that killed your father, your son, and your brother, but I am innocent. Number 2. Joe Arady.
Soon after, a 21-year-old man named Joe Arady was arrested while wandering aimlessly near the local railroads, and he confessed the crimes outright. Joe had always been highly suggestible, and he was a handicapped young man with a very low IQ. His IQ was only 46, and Arady could be coerced into saying or doing anything.
The theme of police coercion continues in this harrowing tale of Joe Arady, executed using lethal gas in 1939 at the age of just 23. The worst part about his wrongful conviction was that his sentencing largely relied on a false confession which Arady gave whilst being questioned by authorities. The key factor in the coercion was that Joe Arady was said to have an IQ of 46 and the mind of a 6-year-old child. The powers that be took advantage of him unnecessarily, as the crime of rape and murder of 15-year-old Dorothy Drain and the attack of her 12-year-old sister Barbara Drain was committed by that of a laborer who worked for their father named Frank Aguilar. The murder weapon was recovered from Aguilar's home, and Barbara Drain, who survived, testified that Aguilar had been there during the attack, but not Joe Arady. Aguilar was convicted and executed in 1937, but Arady stayed on in prison, and surprisingly, the warden, Roy Best, recognized the young man's fate and openly campaigned to save his life. Best was said to be crying during the execution and had pleaded for Arady to be pardoned. 70 years later, an attorney named David A. Martinez took on the challenge of posthumously clearing Joe Arady's name. In 2011, Governor and District Attorney Bill Ritter gave Arady a full pardon. Number 1. The Griffin Brothers. There isn't much detail about Thomas and Meeks Griffin, as their case is over 100 years old. But what is clear as day is the pair were unfairly and wrongly executed after another man testified against the two brothers in order to save himself. John Stevenson, a small-time thief, cowardly dobbed them in when he was found to have in his possession the victim, John Q. Lewis's pistol. Lewis, a white man, was allegedly having a relationship with Anna Davis, a black woman in the community. The people from the area had suspected that, due to a cover-up of the white men not wanting to reveal a scandal due to race relations, Thomas and Meeks were dragged into the forefront and wrongfully convicted. They were executed by electric chair in 1915, even after 100 people in the community petitioned for their sentence to be commuted. In October 2009, the two brothers were pardoned after their great-nephew Tom Joyner reached out to the State Appeals Court of Columbia, South Carolina,